Good afternoon, everyone. This is Bhavya Srivastava, Assistant Professor Law from IIMT College of Law, Greater Noida. Today, I'll be teaching Employees Compensation Act, and let's proceed with the introduction. So, the main objective behind implementation of Employees Compensation Act 1923 was to provide payment by employers to employees in the form of compensation for any loss or injuries suffered by the employees in an accident. At the time of enactment, this act was referred to as Workmen Compensation Act, but later on it was renamed as Employees Compensation Act in 1923. So the same was done on 18th of January 2010, and the reason behind that is that now employees in clerical capacity are also entitled for compensation. This legislation was very beneficial in its terms. It is also a social security legislation. It is of grave importance not only in earlier era but also in today's times. Now let's proceed further. So, for any organization or company, employees are considered to be the most important asset and a valuable source. It is upon the employees to raise the standards of the company or organization, and also their work can degrade it. So, overall, they play an integral role in success of a company. Their major or key function is to achieve the desired goals in a company. In return, they do expect certain kind of security from the employers in the form of security of their jobs and compensation or any sort of expenses incurred by them for the success of organization, which I don't think is too much to ask in terms of what they are giving to the organization. An employee ensures the success for an organization by meeting deadlines for work on time and ensuring customer satisfaction. Now, when it comes to employer, it is very important to understand its meaning. So, for that, let's refer to Section 2E of Employees Compensation Act 1923. Anybody of person, whether incorporated or not, managing agent of employer, legal representative of deceased employer. Now, these are few among others which fall in the definition of the employer. So, if we move further, then we have to understand few other terms which form part of this provision, which form part of the Compensation Act. And in order to understand the Act further and to apply the true inferences, we need to understand various definitions. So, first of all, we'll understand the definition of dependent, which is very important for this legislation. Dependent is defined in section 2D of Employees Compensation Act 1923. The word dependent includes the following relatives of a deceased person, such as widow of the deceased person, a minor legitimate child, unmarried legitimate daughter, or a widowed mother. A son or daughter who has attained the age of 18 years and is infirm, or a person who is completely dependent on the earnings of the employee at the time of his death. A person who is partially or completely dependent on the earnings of deceased employee, and this may include a widower, a parent apart from the widower mother. In case no parent of the workman is alive, then a paternal grandparent and a widowed daughter in law. So dependent also includes some other relations in respect to person partially dependent, but for an insight we can say that dependent is someone whose source of livelihood was earning of that deceased workman. So after going through the various definitions, if we read this definition of dependent and we see what all fall in the category of dependent, then we can analyze that all the persons who were dependent on that person or who were actually in the need of the care of that person are termed as dependents. So in some families, there is this person who is the sole breadwinner for the family or on whose shoulders the entire responsibility of the entire family lies. So if we see, then majorly the spouse, the children, and the parents fall in the category of dependents. So the employee who becomes deceased leaves behind a family comprising of children, spouse, parents, etc. So dependents are those who are actually dependent on that person, and a son or daughter who is though attained the age of 18 years but yet dependent on the earnings of the employee is also in the category of dependent, and widower is also a part of the dependent. So apart from these, there are also certain other relations which are in the category of dependent. But if we are focusing on this topic now, then to summarize, we can say that when the source of livelihood is the only income of the dependents in terms of their survival, then those people are termed as dependents. Now let's proceed further. So we are reading Employees Compensation Act, but for that we also need to understand the definition of workman. Not everybody falls in the definition of workman. So the term workman includes any person except those whose employment is of casual nature, or a person who is employed for the sake of employer's business or trade. One who is not permanently employed in administrative district or subdivisional office of a railway but is a railway servant as defined in the section 3 of Indian Railway Act. Employee is defined in schedule 2. So the act is applicable to all such people who are employed as cook in hotel, liquefied petroleum gas, restaurants using power, etc. Now, if we move further, then there is this term called partial disablement. Now, what do you mean by disablement? So, disablement is usually of two categories, that is partial or total. So, disablement can mean the loss of cognitive faculties or the capacity to do work. So, now let's understand partial disablement. According to Section 21G of Employees Compensation Act 1923, it can be classified into categories, that is temporary and partial disablement. It is a situation in which earning capacity of an employee decreases due to temporary disablement to perform his duty in the course of employment. Now, what is permanent partial disablement? In such a situation, the earning capacity of employee is deemed to be reduced permanently in every course of employment that he was capable of taking at that time. Now, if we take an example, now supposedly there is this one person who is involved in the technical job of welding things. So if he damages his eye, then he it can lead to inference that he cannot do any other work. So it can be termed as permanent disablement. Now if he damages his hand, then he can do some other work which does not involve much skill. So it can mean partial disablement. So now let's move further. So total disablement according to section 2L of Employees Compensation Act 1923 can be classified into two categories, that is temporary total disablement. In this case, the injury is such that it causes disablement of a nature which leads to incapacity of performing any duty as he could at the time of accident. Now, what is permanent total disablement? It includes any injury as specified in Part 1 of the Schedule 1. Further, total disablement includes those injuries as specified in Part 2. Now let's move further to employer's liability for compensation, or what is employer's responsibility as far as the term compensation is comprised. So this is the whole purpose of the act. If we are talking about Employees Compensation Act, then the whole purpose of the act is to provide compensation to employees who suffer injuries due to accident in the course of employment. As per section 3(1) of the act, an employer is liable to pay compensation to an employee under the following circumstances. In case of any sort of mental injury, physical injury, or bodily injury is caused to employees, that is, personal injury takes place, then the employer is definitely responsible and liable to pay compensation to the employee. The accident that has occurred out of or in the course of employment is a necessary condition for this. The injury caused in such that is leads to death, permanent or total disablement, or say partial or total disablement of employees. So this is a necessary condition that the injury cause should not be of ordinary nature, but either it must have resulted into death or permanent or temporary disablement, or say partial or total disablement of the employees. So the injury is caused out of employer employee relationship. Now we had discussed term out of employment, that is arising out of employment, and during the course of employment. So let us first understand the scope of arising out of employment. The term arising out of employment includes conditions, nature, incident, and obligation of employment as well. If during a worker gets injured due to any of the above listed factors, then it would be termed as injury arising out of employment. So now there is this very important case, which is a landmark case in terms of the injury arising out of employment. The name of the case is Oriental Fire and General Insurance Company Limited versus Sundar Bhai Ramji case. In this, the scope of term arising out of employment was determined by Gujarat High Court. In this case, the laborer was performing the hard labor which involved physical exertion. So one day, a laborer, after performing his duty for 3 hours, felt a pain in the chest and fainted on spot. Later on, when he was taken to hospital, he was declared dead. Then, on observing the case keenly, the commissioner found out that it was his duty which caused him physical discomfort and pain, due to which he died, and hence he declared that laborer died due to the nature of his job. Furthermore, the High Court of Gujarat upheld the decision of the commissioner that the injury was caused under the subhead of arising out of employment as specified in section 3(1) of the Act. It was his personal injury that led to his death and has a direct nexus with the employment. Moving further, scope of arising in the course of employment. So the term arising in the course of employment implies accident that took place in the course of employment. It involves injury arising out of the risk incident to employment. A very important factor to make employer liable is that the work performed by employee was at that time and place which is similar with employment. Now this is a very important case out after which the concept would be crystal clear. In this case, National Iron and Steel Company Limited versus Manorama, the deceased was a boy working at a tea stall outside the factory. His duty was to serve tea to the employees of the factory. One day, after serving tea while he was on his way back from the factory, he crossed a violent mob of workers. Police, in order to protect themselves, shot at the mob, and accidentally and unfortunately, the bullet hit the boy and he was killed. The court held that since accident took place during the working hours and at the place of employment, hence deceased boy would be paid compensation. So now let's move to doctrine of notional extension. So the doctrine of notional existence came into force when there is a sort of link between the time and place of work and accident. In such a compensation is payable by employer to employee according to the provisions of the Act. This doctrine was laid down in the following case. Now let's move to the case in Mundra and Company versus Bhavani case. A truck driver, after taking due permission of the employer, went inside the tank of the truck to check the source of the petrol leak. He lighted a matchstick inside the tank, due to which accident took place, and driver sustained huge burn injuries and eventually he died. So what the court held was that since accident took place at the time and place of work, hence dependents of the employee were entitled to compensation. Now we have studied in what conditions or in what times the employer is liable for compensation. Now we will read when the employer is not liable for compensation. So, according to section 3(1) of the Employees Compensation Act 1923, an employer is not liable for payment of compensation in the following circumstances. So, if the injury not leading to death or permanent total disablement of employee, then in case the injury is caused in such a case that it does not cause entire or partial disablement of an employee for a period exceeding 3 days. Now, this is one such point. Second point is that if the injury not leading to death or permanent disablement of employee is caused by an accident which is directly attributable to the employee at the time when accident took place is under the influence of any sort of drugs or drinks due to which he is not in senses or say in the right frame of mind. Now, another point would be that if he or she willfully disagrees or disobeys an order mentioned to them or framed for their safety purpose. Now, another would be the willful denial or non usage of any kind of safety equipment duly provided to them for the purpose of securing their safety while working. So these are kind of the safeguards that are meant for the protection of the employees, and if they voluntarily or negligently disobey them, then they cannot be held entitled for compensation from the employer. Now, what is doctrine of added peril? According to this doctrine, whenever an employee outperforms his duty, that is, he does something which is not the part of his duty as well as it involves some sort of extra danger, then the employer cannot be held responsible to pay compensation for the injury arising out of any such act of the employee. This further disentitles the employee from claiming any sort of compensation on the basis that such danger was taken by employee at his own risk and the same was not required by the employer in the course of employment. Hence, assuming that such injury is not arising out of the employment, employee will not be entitled to any profit at all or compensation from the employer. So let's proceed further. Now, there are some important case laws which we need to discuss in order to understand this concept better. So, the first case which we are talking about is that of Devi Dayal Rai Ram versus Secretary of State. Now, what happened in this case was that a person appointed at the job of a fitter went under the operating machine to collect scrap in order to make some nuts and studs out of it. The machine, when set in motion, caused permanent injury to the employee. On analyzing the case, it was drawn that Peter was prohibited from doing so, and it was not part of his duty to go under the machine and search for the scrap. Hence, all the damage or injuries caused to the fitter were due to his voluntary actions, and there was no duty imposed on him to do so. Further, the court held that employer can use doctrine of added peril as defense for pleading the non-liability in case of compensation. Now, another yet remarkable case is that of Lancashire and Yorkshire Railway Company versus Haile. What happened in this case was that an employee appointed to a railway company while going to the mess room took the path through metal lines, being well aware of the goods train standing by the side. But suddenly the train started and employee was killed. So on observing through clearly, it was held that the accident that took place arose out of the employee's negligence and the risk taken by him, it was not out of the employment of the employee. So, as a result of this observance, court laid down the doctrine of added peril as an imperative of the injury arising out of the employment. Now, what is self inflicted injury? So, in literal sense, we all can understand the meaning of self inflicted injury. However, let's see in the terms of this act. If an injury caused to employee is self inflicted, that is, they are themselves responsible for the cause of the injury, whether it may be intentional or accidental. In such a case, employer may not be held responsible for payment of compensation. Jobs like law enforcement, medical employees, farmers, teachers, salespersons involve a high risk of self inflicted injuries. So, self inflicted injuries and suicides cannot be termed as accident in the course of employment. Now, what is contributory negligence? It is held that employees also have a duty towards employers to perform their task with utmost care and attention so as to avoid any sort of injury or accident. So, although employers are deemed to be vicariously liable for the employee's negligence, but they are also entitled to claim contribution or indemnity from their negligent employee in appropriate circumstances. However, in case there is a negligence on part of both employer and employee, then the employer is only liable to pay compensation to the extent of his own negligence, but not the employee. Therefore, the only benefit is that compensation amounts may reduce because the employer will not be liable to any sort of negligence committed on part of the employer. So, what is employer's liability when the contractor is engaged? Sometimes an employer, instead of directly employing an employee for the sake of doing work or trade, may hire the same but through contractor. So, now in such a case, what if injury is caused to employee due to some accident, or who should be held responsible? So, Section 12 of the Act defines the employer's liability in case contractor is involved. Section 12 defines that when a contractor is involved in some sort of work, then the employees are also involved in the course of employment. And if the accident has occurred at the place, that is where the principal or employers is undertaken to manage and execute the concerned work, then there is employer's liability. So, now proceed to what is the amount of compensation. Section 4 of the Employees Compensation Act 1923 defines the amount of compensation when death results from injury. So, if the employee dies due to such reason, then amount payable is equal to 80,000 or 50% of the monthly wages multiplied by the factor as per mentioned in Schedule 4 of the Act, whichever is more. So now when permanent total or partial disablement is caused by the injury, then there are the different factors. In case of total, there is 90,000 rupees or 60%, whichever is more. And in case of partial disablement, there is 90,000 or 60%. So now what is the liability of the insurer? So liability of the insurer is determined on the basis of wages paid to the employees. So the insurance policy also covers the wages of the employers, and the insurer is liable only to pay the amount as covered in the wages. Distribution of compensation is governed by the section 8 of the act, which talks about the rights of the heirs of dependents in terms of compensation. Let's proceed further. Okay, so there is a amount given that is depends on the lump sum amount which is granted by the commissioner, and that has to be paid as per the order of the commissioner by the employer to the dependents of the employee. The proceedings before the commissioner are governed by section 20 of the act. A commissioner is that authority appointed by the central or the state government. We also have provision of appeal under this act if the party or the aggrieved person is not satisfied with the order of the commissioner, then he can definitely appeal under section 30 of the act. So this was it about the Employees Compensation Act. We have dealt with the meaning of the dependent, the meaning of the employee, and the authorities which are present. If we proceed, if we like to discuss this point in detail, which talks about the distribution of the compensation, then definitely the amount of compensation has to be deposited to the commissioner in case there is no direct payment of compensation, because there are many loopholes or lacunas involved. So, if there is no direct payment of compensation, then the amount of compensation has to be deposited by the employer with the commissioner and has to be given to employee's family who is injured or death. Also, in case of legal disability, no lump sum payment can be made. And in case dependent receives the payment of compensation from employer in case the employee is already dead. So the amount of compensation shall be equal to 3 months wages of the employee. In case the amount payable to defendant exceeds, it shall be deducted by the commissioner and returned to the employer. Now that is very important provision because there can be no excess compensation. What you can say that there can be no profit making from the amount of compensation. It is just to make good the loss or in terms to provide you with a sense of social security. So, as we all know that this is a social security legislation, its aim is to provide benefit to the employees or their dependents. So, hence we can say that this Employees Compensation Act 1923 is a social security legislation. It not only aims to provide compensation in terms of money or like buys to the deceased person or the dependents, but it also aims to provide a social security in terms of livelihood, status, living, etc. It is a very vast legislation which governs various details such as dependents, workmen, etc. There are various authorities under this act. However, we have dealt with all the important aspects of this legislation. We have dealt with the compensation, the kind of disablement, who's the authority under the act, and how is the compensation disbursed under this act. So, to summarize, I would like to say that though the act is of 1923, yet it is of great significance in today's time also. With the changing needs of the society, the act needs little bit amendments. However, it is not obsolete, it is at par with today's dynamic era. There can be few amendments suiting to the present needs of the society. So, I would like to end today's lecture by concluding that this lecture is of great significance, and the Employees Compensation Act 1923 is of great importance and significance. It is a part of social security legislation and an integral aspect of the labor law. Though the labor laws are undergoing a huge change and we have new codes added, still the importance and significance of this legislation as it was there in 1923 has the same in the current era of 2023. So, thank you. I would like to end this session.